I receive a lot of questions from foreigners asking about land purchase or land leasing in the Philippines. I also get many comments left on my channel claiming that someone knows someone that found a loophole or has gotten around the law. I have seen videos, often from foreigners, saying the same. Such foreigners even give advice about the laws in the Philippines they know nothing about, such as how it's possible to form a corporation or have a contract drawn up by a lawyer to circumvent the ownership restrictions. When you ask them about the anti-dummy law, their reply, more often or not, is often anti-dummy what? But more often it is delete and block. One couple, both foreigners, are claiming that they bought their house and lot on a CCT condo certificate of title, but the problem with that is others in the same development have bought on a TCT or transfer certificate of title. So the master deed covering the entire development cannot be registered with the Bureau of Lands and owned by a condo corporation if it is being subdivided and transferred as TCTs. So something smells very fishy. When I told them to be careful, I was told I was a killjoy. But now I see the motive as they are now trying to sell house and lot packages in a subdivision as condos to other foreigners for commission, claiming they found a loophole in the law. I need to explain that there are many types of laws in the Philippines. The highest law of the land is the Constitution, but there are also legislative, which is made up from statutes, resolutions, legal codes, and others. Then there is the executive, such as the administrative orders, proclamation, and official decrees, etc. There are also administrative laws, such as ordinances and regulations, tough up by the judicial, which are made up from judgment, court decisions, and judicial rules. Sometimes, laws conflict with one another, and there is even a section for anyone taking a law degree how to deal with conflicting laws. Since it is the judicial branch that interprets the law, over time, the laws are refined. Judges make decisions are appealed, and eventually the Supreme Court sets jurisprudence. If a similar case goes before the courts, jurisprudence in coordination with the law determines the outcome. If the base laws are changed, then the law is tested and a new jurisprudence is set. So, I decided, in order to make this video, I need to get some ground rules. I will only talk the laws generally, and I will quote the laws and the jurisprudence, which I refer to as bases. I will try and give illustrations and example. So, since I have touched on it, I will start with a question I get asked often is, why can a foreigner own a condo but not a house and lot? The basis is Republic Act 4726, otherwise known as the Condominium Act, which defines what a condo corporation is. The easy way to explain it is, imagine an area of land, say 10,000 square meters, and the developer builds a couple of tower blocks of apartment. Each block has 100 apartments, so 200 apartments in total. The entire 10,000 square meters is covered by a master deed. A corporation is formed, and the corporation owns the 10,000 square meter lot in the corporation's name, remembering that a corporation can own land, and 40% of the corporation owning the land can be owned by foreigners. So the corporation, which will be a non-stock non-profit corporation, will be the legal owner of the land. The 200 apartment owners will each become a shareholder of the corporation, but because it is a non-stock non-profit corporation, they are called members, and the directors managing it, selected from the members, are called trustees. So when a foreigner buys a condo unit in such a development, they are actually buying a share in the corporation which owns and maintains the land and common areas, which is financed by a payment known as condo dues. Since they are not buying any land, they are not breaking the restriction on purchasing land in the Philippines. Now, there are developers that are renting the land to the condo corporation, so the condo corporation and the shareholders don't own the land and that the condo is built on. That's one reason I avoid condo developments, as such important information is often hidden from investors or buyers until it is too late. So when someone says they have bought their house and lot on a condo title, they would actually be buying a share of a condo corporation that owns the master deeds to the entire development, or leasing the land covered by the master deed. While it is possible that 200 apartments could be built as townhouses on the 10,000 square meters lot, instead, for it to become a condo development, all the 200 townhouses would need to be sold on condo titles and all the land owned or leased in full by the condo corporation. This falls apart when the property is being sold as a house and lot, as it is not possible to sell some on transfer certificate of titles to Filipinos while selling some on condo transfer certificate of titles to foreigners. It will be like selling individual pieces of a jigsaw. The law is clear, quote unquote, title to the common areas, including the land, or the appurtenant interest in such areas may be held by a corporation specially formed for the purpose, herein known as the condominium corporation, in which the holders of separate interests shall automatically be members or shareholders to the exclusion of others in proportion to the appurtenant interests of their respected units in the common areas. For illustration, I have a lot I am planning to build some houses on for rental. If I made it a minimum of 5 rather than the 3 I plan, I could form a condo corporation and transfer the master deed of the entire lot to the corporation. All 5 houses could then be sold or transferred on a condo certificate of title, 2 of which, or 40%, could be sold to foreigners outright. The remaining 3 will have to be owned by a Filipino, and since I was planning to build 3 or for rental anyway, it will give 2 foreigners the only way to legally own a house in the Philippines other than leasing. But they would actually own 1/5 of the corporation that owns the land, and all the 5 houses sit on it, and each will be a director or trustee of the corporation that owns the land, which requires a minimum of 5 to form a corporation. The corporation code was recently changed, allowing the corporation indefinite life, not the original 50 years. So, any foreigners who bought one of the houses would have a property indefinitely that they could pass down through the generation. If they sold it, they sell their share in the corporation. I think it illustrates the situation perfectly, and maybe something I should consider, as Old B thinks it is a good idea when I told him about the illustration for this video. Old B is now signaling me for something. I'll just finish this. Another question I get asked a lot is, what is the maximum length of the residential leases in the Philippines? There is a lot of confusion, and many claim the answer to such question is 75 years, a 50-year plus 25 years. While Republic Act 7652, otherwise known as the Foreign Investor Long-Term Lease Act, allows the long-term lease of private lands by foreign investor up to a maximum period of 75 years, 50 years plus 25 years, There are additional requirements including registering a business with the Department of Trade and Industry. However, the implementing rules and regulations of Republic Act 7652 defines what qualifies as investments. Section 1 of the implementing rules and regulations authorizes such leases only for the purpose of and in connection with the establishment of industrial estate, factory, assembly or processing plant, agro-industrial enterprises, land development for tourism, industrial or commercial use, and or other similar priority productive endeavors. But since most people are asking about residential, therefore, Republic Act 7652 would not apply because they are not investing in the Philippines as defined by Republic Act 7652 and therefore shall continue to be covered by Presidential Decree 471 and other existing laws in lease of lands of foreigners. Presidential Decree 471, which covers such leases, states on Section 1, the maximum period allowable for the duration of leases of private lands to aliens or alien-owned corporations, associations, or entities not qualified to acquire private lands in the Philippines shall be 25 years, renewable for another period of 25 years upon mutual agreement of both lessor and lessee. Section 2. Any contract or agreement or executed in violation of this decree shall be null and void ab initio, and both parties to the agreement shall be punished by a fine or not less than 500 or not more than 1,000 pesos, or by imprisonment of from 6 months to 1 year, or both in the discretion of the court, provided that the president or managers and directors or trustees of corporations, associations, or partnership violating this decree shall be criminally liable in lieu thereof. So, when it comes to residential, it is 25 years plus 25 years. Anyone tells you different has been drinking too much Red Horse. Another question I get asked a lot: is the lease payable on monthly or yearly or in full for the amount of the 25 years plus 25-year lease? Article 1687 of the Civil Code states, if the period for the lease has not been fixed, it is understood to be from year to year if the rent agreed upon is annual, from month to month if it is monthly, from week to week if the rent is weekly, and from day to day if the rent is to be paid daily. However, even though a monthly rent is paid and no period for the lease has been set, the courts may fix a longer term for the lease after the lessee has occupied the premises for over 1 year. If the rent is weekly, the courts may likewise determine a longer period after the lessee has been in possession for over 6 months. In case of daily rent, the courts may also fix a longer period after the lessee has stayed in the place for over 1 month. Although it is called leasing in Article 1687 of the Civil Code, such transactions are really renting. A lease, on the other hand, can have value. If you are leasing land and the land in the area goes up, your lease could have value to a third party. And so it depends on the landowner now if they want to rent, lease, or sell their land. When I rent my guest house, I don't need to do an agreement, and people can pay daily, weekly, or monthly depending on the stay. At any time, I could stop taking payments and give notice. That is not a major problem for the renter, but imagine that was a plot of land someone hoped to build a house on. In that case, it would be beneficial to the leaseholder to have security, and the law provides the maximum security is to lease a residential property for 25 years, renewable for 25 years. It will be possible to decide the terms for renewal after the first 25 years at the start of the lease, making the lease in effect 50 years. Many landowners who are giving up the use of land for 50 years would rather sell it. If I entered into a 50-year lease, it would mean in my lifetime I would not have the use of the land again. I will consider it gone. Another question. Under what circumstances can a lease be broken? The Civil Code answered that question. The lessor may judicially eject the lessee for any of the following causes. 1. When the period agreed upon or that which is fixed for the duration of leases under Articles 1682 and 1687 has expired. Number 2. Lack of payment for the price stipulated. 3. Violation of any conditions agreed upon in the contract. 4. When the lessee devotes the thing leased to any use or service not stipulated which causes the deterioration thereof, or if he does not observe the requirement in number 2 of Article 1657 as regards the use thereof. But once again, we are talking residential here. The ejectment of tenants for agricultural lands is governed by special laws. There will be little point having leases if the lessor can evict the lessee with cause any time they wanted the land back by just refunding the lease payments while keeping any improvements. This is all covered by contract law, and it is possible to include in the contract provisions the builder of the house is compensated by the landowners the full market value for any structure built upon the leased land if the lease is terminated early or for that matter even after 50 years. But even without that clause and provision, the Civil Code provides some protection because Article 1678 states, quote unquote, if the lessee makes, in good faith, useful improvements which are suitable to the use for which the lease is intended, without altering the form or substance of the property lease, the lessor, upon the termination of the lease, shall pay the lessee 1/2 of the value of the improvements at the time. Should the lessor refuse to reimburse said amount, the lessee may remove the improvements even though the principal thing may suffer damage thereby. He shall not, however, cause any more impairment upon the property lease than is necessary. I have had many comments from foreigners informing me that they own the house and the wife owns the land. It doesn't actually work like that without planning and documentation. The law allows for it, but it needs correct registration and documentary proof with the Registry of Deeds. Otherwise, if there was a dispute, the court would want proof or it will be considered that the Filipino who owns the lot also owns the house on the lot. To complicate matters, many house and lot packages sold in subdivisions make it an encumbrance on the title that the house and lot package is apportioned to mandatory membership to the homeowners association and cannot be separated. One of my favorite comments often made is the commenter knows someone who had a top lawyer draw up a contract that gave the foreigner the power of attorney over the property that is in his girlfriend's name. But he has a blank deed of sale and an agreement that he administers the house and. I remember I mentioned jurisprudence. Well, there was a case that went before the Supreme Court, bought by a foreigner who thought he had beaten the system with his lawyer, drawn up agreements, and power of attorney. The foreigner, an Italian, had a lease prepared by a lawyer for 50 years plus 50 years. He also had a contract agreement that he would administer the leased land and house, and he had a power of attorney to have jurisdiction over the property. It was noted that he had paid for the house and lot, but it was to remain in his girlfriend's name. It was all prepared and correctly registered, but when challenged, the lease was null and void, as it is not possible to have 100-year lease, and the foreigner lost the possession of property he paid to have built, as there was no valid lease contract between the parties and the property was in his girlfriend's name. Often in such cases, the legal maxim, "Mimo cum alterius deter detrimento protest," that means no person should unjustly enrich himself at the expense of another, form the basis of many illegal actions. Attempts are made not to recover the land, but to just recover the monies paid. But the problem is, since the foreigner knows that he cannot purchase land in the Philippines, but attempts to circumvent the law in any way, such as having an agreement that allows him to force a sale or have funds from the sale, then he is exercising a right over land prohibited to him by the Constitution from having. So when I read comments or see videos where foreigners are stating, "I purchased the land, but it's in a Filipino's friend name and it's all drawn up by a lawyer, so I am protected. The land is mine and I get money back when I sell it." Now, if the friend turned rogue and decided not to sell the land and just honor the lease, and if the foreigner challenged it, they would lose because they knowingly tried to circumvent the law. So the legal maxim, "Mimo cum alterius deter detrimento protest," again, no person should unjustly enrich himself at the expense of another, would not apply as he came to court with unclean hands. Now, a lawyer will say, the foreigner has a case. The lawyer is correct. He has a case. And the lawyer will fight the foreigner's corner, collect his fees up to the day he loses. It's like backing the three-legged horse in a horse race. You know that it won't win, but you hope anyway. Often when the Supreme Court shoots down in flame another attempt by a foreigner to circumvent the laws, it relies on the fact the foreigner knew of the prohibition and he attempted to circumvent the law. Sometimes the foreigner puts forward a good argument based on law and jurisprudence, but it's soon reminded that he has come to court with unclean hands, so the court cannot give the relief he seeks. That is why you often hear the foreigners always loses, which is true if it involves circumventing the law on land ownership. I think this should be enough to get people's brain cells going. Old B is now insisting to have his lunch. I'm sure there will be many questions arise. Some I will get around to answering, but before, as a viewer, you start answering other people's question, you need to back up your claims with law and jurisprudence. Don't come to the comment section and say you know a friend whose uncle's best friend's sister spoke to a judge who said so and so. You need to back up your claims, otherwise, fair warning, you are opening yourself up to ridicule.